Good afternoon, everyone. Welcome to this event here at the Faculty of Law, organized in partnership with the Center for Comparative and Public Law. My name is Alex Schwartz. I am assistant professor here and deputy director of the Center for Comparative and Public Law, and it's a pleasure for me to be chairing this particular event today and introducing our two speakers who will be speaking from different angles about issues relating to Brexit. So the phenomenon of Brexit, the decision, process, and still, I think, murky, uncertain outcome of the UK leaving the European Union is, I think, one that continues to excite and delight some people, frighten, confuse, and shock other people, not just within the United Kingdom, but around the world. We've had, there are countless academic events that have been organized to ponder its significance, and today is actually the second Brexit-themed event we've hosted here at the Faculty of Law this week. So I am actually not surprised by the extent of interest. The strange thing about Brexit, I think, or at least one of the strange things, is that even if you aren't at all interested in Brexit, you are probably interested in Brexit. What do I mean by that? I mean, even if you don't at all care whether it's a good or a bad thing for the UK to leave the European Union, and you don't at all care about how that relationship between those two entities might evolve in the future, you still probably care about a lot of the big issues that the Brexit phenomenon provides a window on. So, big questions to do with the deep structure and direction of constitutional law in the United Kingdom, and perhaps beyond the United Kingdom. Big questions about the law and politics of referenda, tensions between popular sovereignty and the rule of law, and tensions between national identity and more, let's call them, cosmopolitan values. So I could go on and on and on. And today we're very fortunate to have two great speakers who will give you some insight, and I think from two very different angles, into this multifaceted phenomenon of Brexit. So it's my pleasure to introduce Dr. Mara Malagodi, Senior Lecturer in Law at the City Law School, University of London. Amongst other things, she is an expert on South Asian constitutional politics, and particularly Nepal, and I can highly recommend her book, Constitutional Nationalism and Legal Exclusion in Nepal, published with OUP. We also are very fortunate to have here Sebastian Payne, who is President of the UK Constitutional Law Association, Senior Lecturer in Public Law at the Kent Law School, and a Barrister of Inner Temple. He is, amongst other things, an expert on parliamentary oversight of intelligence and security services, and I can highly recommend his book with Mara Malagodi, The Nature of the Crown, a Legal and Political Analysis with Clarendon Press. So we'll actually be hearing from Sebastian Payne first, and so without further delay, I would like you to join me in welcoming our two speakers here today.
Thank you very much, Alex, for that very kind introduction. And also, could I thank the Center for Comparative and Public Law for so kindly inviting us today to give this talk. And it's a great pleasure to be back in Hong Kong, a place I know very well and love being here. My talk today is on the UK Supreme Court, the Constitution, and Brexit. And my talk focuses on the Miller case and the role of the courts. It dealt with a matter of great constitutional importance. So what was the Miller case about? I know many of you will know a bit about it, some of you know all about it, maybe more than I do, and some of you will know little about it. But I'll give a short account of the context. After the UK voted to leave the European Union in a referendum in June 2016, the Conservative government wished to give effect to that vote by notifying the European Council of its intention to withdraw from the European Union under Article 50 of the Lisbon Treaty. Article 50, subsection 1 said this. It said, any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. As you may well know, Article 50, subsection 3 says that the treaties will cease to apply to the member state from the date of the withdrawal agreement, that's the agreement negotiated between the UK and the European Union, or failing that after 2 years, unless the European Council and the member state unanimously decide to extend the period. So the UK gives notice, an agreement is drawn up. If agreement is not reached, which now looks quite likely in some ways, anyway, the treaties cease to apply after 2 years. Notwithstanding that one of the key arguments of the Brexiteers, those who wanted to leave the European Union, was about the sovereignty of Parliament, the government did not want to get the permission of Parliament to serve the notice. They didn't think that it was needed or necessary. They thought there was no need for an authorisation by an Act of Parliament. Instead, they proposed to use the royal prerogative, which is a form of executive power, to give notice. So they wanted to use an ancient source of power. The key issue in this case was whether the royal prerogative extended to giving notice to leave the European Union, bearing in mind that the giving of notice would lead to the EU treaties applying, thereby terminating an extensive legal order, namely EU law, which had been applicable and binding in the United Kingdom. So the effect of giving notice using this executive power would be to completely remove this legal order. And because the United Kingdom is a dualist state, with regard to international treaties, the European Communities Act 1972 was the means by which EU law was made effective domestically. That act said, in effect, apply EU law in all its forms. So I simplify, but that was the function of the 1972 Act, to put the whole body of EU law into effect. Crucial to the case, the Miller case, was an interpretation of what the 1972 Act was doing. Was it a mere channel or conduit to put into effect whatever flowed from the treaty obligations? So that was an argument discussed at length in the Supreme Court. Or did it do something more, namely introduce a new and binding legal order, thereby transforming the legal structures of the state? Related to this was the question of whether a prerogative could effectively terminate the contents of an Act of Parliament. So that was a key issue. You have an executive power. If you use that power, would that destroy an Act of Parliament? And also, and very importantly, demolish a whole legal order, this whole body of EU law. The other key element in this case relates to the devolution arrangements in the United Kingdom, dating to 1998, and put in place by Acts of the UK Parliament. The devolved assemblies and executives had limited competence, unlike the UK Parliament, one obligation being to not act or legislate contrary to EU law and to apply it. So that was in the whole exercise of devolution. There were limits to the powers of the parliaments and the executives, and one of those limits was they could not go against EU law, and they had to apply it. As the devolution arrangements developed, an understanding or convention had arisen that the UK would not normally legislate on devolved matters without the consent of the devolved legislatures. This was called the Sewell Convention. So there was a binding understanding, but not a law, that the UK Parliament would not legislate across devolved matters without the permission of the relevant devolved Parliament. And that convention was enshrined in law as well. So it was not merely a convention of the UK Constitution, but had been enshrined in the Scotland Act 2016. So one might have thought it had statutory force too. The question that arose in the Miller case was whether the agreement of the devolved legislatures was needed prior to giving the notice to the European Union, because the effect of giving notice would have cut across devolved matters with regard to EU law. The Supreme Court case was heard by all members of the Supreme Court, which is quite unusual. That's all 11 members of the Supreme Court heard the case, which is untypical of, as you know, of English common law decisions to have such an extensive panel. And the decision of the court was a split decision, and the majority were the 8 members of the Supreme Court. And it's the majority judgment, the judgment that was effective that I'm going to look at. And the majority decision in the Miller case was that the prerogative power relating to treaty making did not extend to this scenario of giving notice to withdraw from the EU, because to do so would undermine provisions embodied in an Act of Parliament. So they said the government did not have authority to use the prerogative. They needed an Act of Parliament because the impact of using that executive power would undermine an existing Act of Parliament. They said an Act of Parliament was needed to authorise the notice to leave. The court, on the other hand, the majority, dismissed the devolution arguments on the basis that the Sewell Convention was merely a political understanding and not law. So that was the sort of overall structure of the set of issues. I'd like to, if I may, look at three of the key concepts that are central to the arguments in the Miller case. And of course, you'll be familiar with some of them, but some of them are quite technical, even though they're terms that are bandied around. So I'll say a few brief words about them, and if you're overly familiar with them, then you'll have to bear with me and forgive me whilst I just outline a couple of the key elements. So three key concepts, I think, in this case. The Crown, the idea of the Crown, prerogatives, which we've mentioned already, and conventions. In the UK, the overarching structure of the state is embodied in the Crown, and that is still the position today. And I think it's very important to understand that, because people often think of the Crown as the person of the monarch. But the Crown, the legal powers of the state and political powers are all wrapped up in this concept. So it's not the person, but the legal idea of the Crown. The structure of the state is embodied in that. Government acts in the name of the Crown, and alongside its statutory powers, the powers it has through Acts of Parliament, it's granted, it has prerogative powers as well. So the government acts with Acts of Parliament and prerogative powers. Prerogative powers, as you may know, were historically powers that the king had, but they still exist. They have the force of law. Originally, they were immune from judicial review, but bit by bit, this has been changed by the courts since the 1960s. And there was, and still is, a legislative manifestation of these powers. So this historical source also gave rise to a lawmaking set of powers called Orders in Council. And I mention these elements because they're central to the way in which the Supreme Court analysed it, and I want to look at that. And the fact that the prerogative powers were regarded as primary legislation. So if you think of the sequence of events, you have historical powers of the king, they still exist, and there is a legislative power as well. Although prerogatives are in principle judicially reviewable, some, such as war powers, are non-justiciable, which for all practical purposes means the same thing. Although wrapped up in this quaint-sounding historical form, many key governmental attributes are directed or controlled by the prerogatives. And just to remind you, such as appointing and dismissing ministers, summoning Parliament, a power to keep the peace of the realm, declarations of war, what could be more important than that, deployment of troops, the recognition of foreign states, but as I mentioned, the making of treaties, which was central here, and the termination of treaties, are executive powers that were wrapped up in the prerogative. So one of the questions to think about is, if you have a government in the legal form of a medieval monarchy, how is it that the UK is something resembling a democracy? And this is where conventions come in, I should say. Conventions are absolutely pivotal to the UK's legal political functioning in the absence of a written constitution. Conventions are understandings and practices of constitutional principle that are considered binding, even though their source is not based on law. So, for instance, it's a convention that the monarch does not exercise her power, legal power to run the government, but appoints the leader of the majority party to do so, although she does retain some reserve powers as head of states. And I mentioned these, as I mentioned, these are central to the workings of the Constitution, these three concepts, and their interpretation and application were also central to the decision in the Miller case. Otherwise, I wouldn't have mentioned them. It's essential to understand that for understanding the case. So a crucial part of the court's judgment is their section on the constitutional background. It underpins their reasoning, and of course, Article 50 requires a notice to leave to be consistent with the country's constitutional requirements. So what I want to do now, if I may, is turn to the judgment and look at the way in which the court presented the issues, how they analysed them. So I want to look at the court's account of the constitutional background, because the way in which they did that, I think, is very revealing about the function of the Supreme Court in a common law system and with no written constitution. So it's a means of judging how well the Supreme Court works and how well an unwritten constitution or common law approach works, which is my underlying theme here. So let's turn to, well, I refer you to paragraph 40 of the majority judgment. They say this: unlike most countries, the United Kingdom does not have a constitution in the sense of a single coherent code of fundamental law, which prevails over all other sources of law. Well, that statement is entirely true. What the UK has is a multitude of precepts of varying status that do not form a coherent whole and may or may not be applied as law, depending upon what the court feels like at any one time is the right answer. This is what I call the pick and mix approach, a little bit like a pick and mix candy store. There are all these ideas floating around, all these concepts, some of which I've referred to, which are all subject to interpretation. And there are different emphasis the court can put on them, and the court, in a constitutional issue, seems to have a lot of latitude. And I describe that in a light-hearted way, but for a serious purpose, the pick and mix approach. It's what some people dignify as the common law approach, but it seems to have an inherent element of uncertainty in it. Indeed, the court quotes Dicey as saying that the UK Constitution was the most flexible polity in existence. Too true indeed, very flexible. Well, the court goes on to say this at paragraph 41, and I quote it. Originally, sovereignty was concentrated in the Crown. Accordingly, the Crown largely exercised all the powers of the state. However, those prerogatives were progressively reduced as parliamentary democracy and the rule of law developed. This potted history by the majority judges is quite misleading. It can be called the Whig account of history, suggesting evolution and progress. Put simply, key governmental attributes remained in the hands of the Crown until this century, and still do, with some recent limitations. So their account is, well, what you see in the judgment is a potted history, some of which is very doubtful, and really quite misleading. The powers of the state are still exercised by the Crown, though not by the monarch in person, I should add. They say this at paragraph 42. Judges impartially identify and apply the law in every case brought before the courts. That is why and how these proceedings are being decided. Well, I have to say I find this particular assertion laughable. I thought that the declaratory theory of justice had long been regarded as a fantasy, or as Lord Reid, an earlier Lord Reid, had described it, a fairy tale. In this particular case, the courts are being asked to determine the extent of the royal prerogative in an entirely novel situation. This situation had never arisen. There was no answer to the existing question. It had never arisen before. In other words, the judges are making up a new rule, and certainly the majority did make up a new rule. Now, I don't regard making up a new rule as a problem, But the Supreme Court is keen to pretend that they are not doing that. At paragraph 43, they say this: the legislative powers of the Crown is today exercisable only through Parliament. Well, that statement is actually false. Ordinance in Council create prerogative legislation. It is referred to as the Crown out with Parliament. And in the GCHQ case, such orders, as I mentioned earlier, were referred to as primary legislation. When I read that, I wondered who had actually written this. It strikes me as very odd that something as manifestly inaccurate is there. It may be that there's a perfectly reasonable explanation, and it's a condensation of something that does make sense, but as stated, it actually doesn't. Well, it's not accurate. Indeed, the Chagos Islands case was involved in the use of orders in council under the prerogative, in which a whole population were banished from their territory. What could be more striking than that? Later in the judgment, the majority do mention in passing a limited power of the prerogative to regulate, but their qualification is still somewhat misleading. They say this: the fact that the exercise of prerogative powers cannot change the domestic law does not mean that such an exercise is always devoid of legal consequences. Well, I find this analysis doubtful. What about orders in council, which we've just talked about? They are prerogatives, and they change the law. Indeed, the government's case was that the prerogatives could change the domestic law, and for my part, I think that's a sounder interpretation. The court, the majority, goes on to give two examples of this sense in which the prerogative doesn't change the law, but is not devoid of legal consequences. This is their formulation. They say the Crown has a prerogative power to decide on the terms of service of its servants, and it is inherent in that power that the Crown can alter those terms so as to remove rights. So the control of the civil service subject to the prerogative. But that was an accurate account, but the court appears to have forgotten the Constitutional Reform and Governance Act 2010, put the regulation of the civil service onto a statutory footing. And this second example, I think, is really quite revealing. They said the court refers to a second category where prerogatives can have consequences. So this is their formula, that it can't change the law, but it can have consequences. And that's the analysis I find rather doubtful. They give this example. In Post Office and Estuary Radio Limited, a 1968 case, the Crown's exercise of its prerogative to extend UK territorial waters resulted in the criminalisation of broadcasts from ships in the extended area, which had previously been lawful. Now, I just want to explain that example, because I think you may be familiar with it. Well, they go on to say the exercise has not created or changed the law, merely the extent of its application. So if you think of what's actually happening in this case, it was unlawful to broadcast radio without some permit from the government. But if you're outside territorial waters, it's fine. So some ships, some radio broadcasts, they've sort of set up ships like Radio Caroline, and they were in the law. By an act of the executive, they said, oh, right, now we're extending the territorial waters. So at a stroke, not through Parliament, but by an executive order, the people on that ship were becoming criminals. Now, if that's not changing the law, I don't know what is. But according to their formula, they're not changing the law. It's a merely status, change of status. Well, you can take your pick who you prefer in that, but I, for my part, find it a very odd analysis. I'd like to turn to conventions. In the majority judgment, the court gives a particular meaning to a convention as an established practice in the political sphere, which is not enforceable by the court. But that starting assumption begs the very question to be decided. It is a proposition that is only true by definition, but not a valid conclusion of a logical argument. I think that the court's reading of conventions is very limited and does not acknowledge that changing political practices and realities do influence the courts. So here are a couple of examples where conventions, which I said are absolutely central to working with the UK Constitution, are important to legal decisions and are given effect. So executive powers are exercised almost entirely by ministers, not the monarch. Take a decision to go to war, a prerogative power. That would be taken by the Prime Minister, although in legal terms it's the power of the monarch. But the person who actually makes the decision is the Prime Minister, but that's not embodied in law. It's convention that the Prime Minister takes the decision. So if someone challenged the exercise of that power by the Prime Minister in the courts would say that the exercise of the power is non-justiciable. War powers, non-justiciable, and so by implication lawful, because there would be no means of challenging it. So there would be a shield to it. So they wouldn't be saying this is an unauthorized exercise of power because the Prime Minister took the decision. So you can't have the legal effect without taking into account the convention. So clearly the court are applying it. Conventional factors, or at least changing of views of what is appropriate, are exactly what has influenced the court in its determination of the limits of the prerogative. And that determination by the courts equals the law. A line of authority limiting the prerogative has responded to a changing sense of what is politically appropriate. Some of the reasoning of the court in Miller on this point seems muddled or, at best, disingenuous. At paragraph 149, they say this: "Judges, therefore, are neither parents nor the guardians of political conventions. They are merely observers. As such, they can recognize the operation of a political convention in the context of deciding a legal question, as in the Crossman diaries." They quote Attorney General and Jonathan Cape. "But they cannot give legal ruling on its operation or scope, because those matters are determined within the political world." Well, when I read this judgment and this statement, I reread the Jonathan Cape case, which was about whether a former cabinet minister could publish his diaries. And the government tried to prevent it, seeking an injunction for breach of confidentiality. But what would give rise to the confidentiality in the common law was a convention that cabinet papers were secret. So it was absolutely central. In that case, there was a dispute between the parties as to what the convention was, both sides calling cabinet ministers to support their view. So there was no clear agreement about the convention. So if you think of the logic of what a judge has to decide, you're given two completely opposite points of view. The judge is going to have to determine the convention, and it was left to the judge in this case too, and that's exactly what Lord Chief Justice Widgery did. He wasn't a mere observer, and he concluded that the Attorney General had made out his claim that confidentiality applied because, and I quote, "the doctrine of joint responsibility within the Cabinet is in the public interest, and the application of the doctrine might be prejudiced by premature disclosure of the views of individual ministers." So, faced with a dispute about the conventions, which was present in that case, the court determined what it was. In fact, no injunction was granted simply because the information was stale, but that doesn't change the point about the court determining the scope and the legal impact of a convention. Now, I want to turn to devolution. I better check with the chair if... 2 more minutes. Okay, 2 more minutes. So there's going to be a sort of relative 2 minutes, but it won't be an actual 20 minutes. Okay, so I did have a fair bit I want to say on devolution, but I'll just paraphrase that because I don't want to hog all Dr. Malagodi's time. So the devolution question was central to the case. All the devolved assemblies intervened and some other parties. And the Welsh government and the Scottish government said the government has to have the agreement of the devolved assemblies. The Northern Irish were quite happy, or rather the Northern Irish government who were... but anyway, so the court had to decide whether the Sewell Convention put into law was binding or not. And the court, just to paraphrase the tale, said it's, again, a bit like the earlier case on convention, said it's merely a convention. And so obviously they're mere observers. And the fact, even more extraordinary, they said the Scotland Act 2016, which I know a lot of Scottish people think, well, there it is in an Act of Parliament. They say, oh no, all it's doing is giving acknowledgement that there's a convention. Well, so they said that was of no importance at all. So that in a nutshell, favourite word of law students and speakers running out of time, in a nutshell, that was the issue on devolution. There's lots of interesting stuff there. Now, to my conclusions. This is my view on the Supreme Court case. And it's really about the function of the court. I mean, I'm only using this case to illustrate what happens when a court deals with a politically highly charged case and feels under pressure. How well does it work? That's, I suppose, I mean, there are lots of interesting things in this case, but this is really the focus of my analysis. I would say, by way of a rider, I do have the greatest admiration for the Supreme Court judges, some of whom I know, and they are very erudite and talented judges. But I think there are very particular reasons, both political and institutional, why, at least in my view, this case falls short, but also reveals something important about the common law. So here are my conclusions. The court was under pressure. It allowed itself to be intimidated into a rushed timetable. The government was pushing, saying we must issue the notice, the Article 50 notice. And there'd been a huge background. There'd been, in the High Court, in the court below, the press had been totally vile about the court, and calling them traitors of the people and all that sort of stuff. The second point is the court was also clearly on the defensive after the terrible press attacks. So, and this is about the sort of situation of the court. So there they are. There's no written constitution. They're under pressure. They allow themselves to be rushed. Their position didn't seem to me very secure. If you look at the majority, my third thought is the majority judgment looks as if it has been stitched together by a committee. It reads in a very, and some of the things, I mean, I'm sure other people won't agree with me, but it seems to me that the content of that is very doubtful, as if, I don't know who wrote it, or how many people wrote it, but there are chunks of it which, as I've suggested, at least to my view, it's not a seamless work of art. It looks as if it was cobbled together in a hurry and under pressure. My fourth point is that there's an absence of clear constitutional principles being deployed, although plenty of rhetoric to that effect. My fifth thought is that some of the reasoning seems bizarre or just plain wrong. And my overall conclusions is that I think the common law approach, the pick-and-mix approach, looks very unsatisfactory, especially when a court is under pressure and lacks confidence. And I think, in conclusion, that the biggest improvement to be made would be to have a written constitution that identifies what the key principles of the constitution are. A written constitution would also be able to empower a Supreme Court to act with confidence. It would allow itself to set its own timetable rather than being harassed by politicians and the press. And lastly, the fundamental obscurity of the UK non-constitution, with the accompanying paraphernalia of the Crown and prerogative, could be replaced with a more certain allocation of power and institutional competence if there was a written constitution. Ladies and gentlemen, thank you very much.
Thank you, Sebastian.
Thank you so much to the Centre for having me here, for hosting me as a visiting fellow. It's a great pleasure to be in Hong Kong. So, what I'm going to do today is actually quite different from what Sebastian has done. Am I doing something wrong with the mic? No, okay. So I want to take you through a number of reflections that I've made on how did we get here. And most importantly, what I'm interested in is to look at the issue of franchise, how the issue of franchise specifically in the European Union referendum, so look at the legal basis for that, and draw some broad conclusions about questions of British citizenship and really questions about British identity. So to do that, I'm going to start by looking at how the European Union Referendum Act was passed, some of the debates. So I'm going to be referring to debates in Hansard at the second reading of the book, of the bill. And I'm going to link that to comparisons with the Scottish independence referendum, questions of franchise, which was actually very different, and hoping to draw some conclusions with regard to the relationship that the UK has, straddling two supranational organizations. On the one hand, the European Union, and then a much longer association, which is that of the Commonwealth, or the former British Empire. And that kind of brings together a number of my interests. So I worked for many years on questions of constitutional identity in South Asia. So the question became, why not turning the academic gaze and those kind of interests to the UK to understand better what's happened? Because I think, in my view, an analysis of the law tells us a lot about questions of identity in these circumstances. So let me start with the question of franchise. Why did I pick that? Because it's peculiar. It's peculiar for a number of reasons. First of all, the legal position in the UK with regard to referenda is that Parliament may decide on an ad hoc basis with regard to franchise. So there is no standard set ad hoc position there. So it's a question entirely in the hands of Parliament what franchise to adopt. So if we start from that legal position, the point that I'm going to put to you is that, especially with regard to the Brexit referendum, which was so politically charged, the legal really follows the political in quite a direct way. So what I want to try to explain today is, why was that particular formula for franchise chosen? What was the impact? And so on. So the position on electoral franchise in the UK is complicated for a number of reasons. First of all, and I think in that the UK is quite peculiar, the question of nationality, the question of citizenship, is distinct. It overlaps with the question of franchise, so who has the right to vote, and it's quite different from a number of other countries. So let's start with a little bit of background. So the UK effectively has two electoral registers. The parliamentary, the one of parliamentary electors, the one for local electors. We also have different ones for the devolved legislatures of Northern Ireland, Wales, and Scotland. But the two main electoral roles and the main differences that I want to think about are the ones between parliamentary electors and local electors. So let's look at who fits the bill and who doesn't. So if we look at parliamentary electors, who can vote? We know this from Section 1 of the Representation of the People Act 1983. So, of course, you have British citizens. So you have, first of all, a criterion of citizenship, so someone who holds a British passport. A criterion of age, someone who's over 18. And you also have a criterion of residence. So if you're British, you can vote, if you're in the UK, of course, but also if you're overseas for up to 15 years. So that seems quite clear-cut, that seems quite comparable to a number of other countries. But we also have a number of other categories which are not quite so immediate, and they're delinked to the question of citizenship and nationality. So that will appear obvious for historical and political reasons. Citizens of the Republic of Ireland are entitled to vote in UK parliamentary elections. Of course, you know, there is a history of a commonality, there is an open border. It's the question of the Good Friday Agreement in 1998. So that we can explain in a way more easily. But you see that here, it's not a question of British citizenship already. So what we have already a category of essentially foreigners being allowed to vote. The second category, which kind of links to my title and the lenses of empire, is Commonwealth citizens who are resident in the UK. So we're talking about citizens of 53 countries, former imperial possessions, that by virtue of residing in the UK, being over 18, are allowed to exercise their right to vote in parliamentary election. Then, if you compare this
with the second electoral register, which is those of local electors. In the local electors, you have a bigger number of electors because you also have European Union citizens. And the inclusion of European Union citizens for local election does not derive from an act of parliament. That's actually a requirement of European Union treaties, which is being translated into directives and then as being domesticated through an act of parliament. So we have these two regimes. So those are already in the statute books. Those were options on the table. So what happens at the time in which Parliament debates franchise for the EU referendum bill? I promised you that my argument was about politics driving the law. So I'm going to start off by looking at the Conservative Party's election manifesto. So I'm going to give you just a couple of lines from the manifesto and the part on the referendum that I brought with me. It is time for the British people, not politicians, to have their say. Secondly, the membership of the European Union, the UK membership to the European Union, depends on the consent of the British people. So my question immediately was, fascinating, so who are the British people? How does the law define them? So if we move on to look at the actual law and we consider government proposals, let me start at the outset. So I went through the bill documents, which are extensive. And if you look at Section 2 of the Act, the Referendum Act, you see that actually throughout the readings, throughout all the committee's stages, remains unchanged. So the franchise section, as introduced by the government, remains in the final enacted version of the Act. So Hansarding that sheds quite a lot of light on the reasoning of the government, on the reasoning of the opposition parties, and so on. So, at the outset, the government claims that they're deploying for the referendum, they're deploying parliamentary franchise. So you would expect the position that I was describing to you at the outset, so British citizens over 18 resident in the UK and resident abroad for less than 15 years, Commonwealth citizens, Irish citizens. But already in the initial version of the bill, you have two categories which are added. So you already have an extended parliamentary franchise in the draft bill. And it's extended to two categories. Well, first of all, peers, so the members of the House of Lords, that would not be surprising. And secondly, to Commonwealth citizens residents who are residents in Gibraltar. That's actually a result of a decision of the European Court of Human Rights a couple of years before, then translated into domestic statute. So the initial position of the government is already a departure from the classical position on parliamentary franchise. So what I want to do briefly is to look at some of these debates and also look at the proposal for some of the opposition parties to extend the franchise and see what are the arguments that the government gives for refusing to do so. So Philip Hammond, who was the Secretary of State for Foreign and Commonwealth Affairs in 2015 and the Member of Parliament that introduced the bill, essentially at the beginning of the speech rehashes the Conservative Party's manifesto and talks about the fact that it's the British people who must have a final say on the EU membership referendum. So that's kind of the starting position. And then you start looking at what other categories do opposition parties want to include. So I'm going to focus on two categories. The first one is the categories of 16 to 17-year-olds. That's a proposal that comes from the Scottish National Party, from the SNP, from the Lib Dem, the Green Party, and Labour supports that as well. You also have a proposal from the Scottish National Party and the Lib Dem to include other European Union citizens who are resident in the UK. So I'm going to focus on those two elements. And I think it's kind of, hopefully will become clear why I do that in the course of the talk. So the opening of the government is, the referendum is about an issue of national importance, and parliamentary franchise must be the starting point. And the idea is that you have to have a deep connection to the UK to be empowered to make that decision. At the outset, the government rejects those two proposals to extend franchise to 16, 17-year-olds and other European Union citizens. What are the reasons that the government gives? For 16 and 17-year-olds, the argument is actually, well, we should instead focus on increasing turnout between 18 and 24-year-olds, which is historically quite low. With regard to European Union citizens, the argument was, well, they might have very different interests from the British people. But what you notice here from the outset is that actually citizens from 3 European Union member states are already part of the franchise proposed by the government. Because first of all, you have Irish citizens, who are by statute usually included, and by virtue of being Commonwealth members, you also have citizens of Cyprus and citizens of Malta. So you already have a degree of discrimination between European Union citizens resident in the UK. Which again brings you to ask, who are the British people then? And what about this Commonwealth connection? What does that mean? So the idea is that it's a different interest. And when I was reading this, of course, the question would be, what about a Canadian student who's in the UK for 3 months on a course? Would they have a different interest, or do they have a sufficient connection? How is that explained? Of course, that's explained through history, the history of the Commonwealth, the history of citizenship laws, and so on. Let me move on to Alex Salmond from the SNP explanation for his proposed amendments to include the youth vote and European citizens. What the Scottish National Party puts forward is essentially the same formula of franchise that they had for the 2014 independence referendum in Scotland. And the justification to me that he gives is the most interesting part. He says, we allowed European citizens to vote in the Scottish referendum because our view of nationality has a civic basis. Unlike Conservative members, with their narrow-minded nationalism and narrow view of people's interests, we take a broad view of the matter. We believe in civic nationalism. We believe that if someone engages in a country, lives in a country, works in a country, and pays taxes in a country, they are entitled to vote on the future of the country. Also, significantly, if you compare franchise in the Scottish independence referendum, you know the Scottish people who were, so people born in Scotland but resident out of Scotland, were not allowed to vote. So really, the main criteria for the Scottish independence referendum is just residence. So it's not this idea of blood, it's not this idea of descent, it's who has a stake in the future of Scotland. And who has a stake is someone who's here and is registered. So I think that's quite significant to look at that in order to explain away what I want to do. Also, Alex Salmond puts in quite an interesting point when he looks at the inclusion of peers in the franchise, and basically points out that you have 6 members of the House of Lords with previous convictions who should be then disenfranchised because of the position on prisoners' voting rights, which is quite a significant point, you know, kind of to provoke, I guess, the government on that, looking at the fact that the UK remains in breach of the CHR on the point of prisoners' voting rights. So I've given you a little bit of an overview. We know what the outcome is. Why is that the case? So I just wanted to spend a few minutes kind of reflecting on why was that position chosen. First of all, I'm going to start with the obvious level, which is pragmatic. You know, you have an electoral roll, it's ready, it's easier for the administration just to deal with that. So it's a pragmatic decision. That's the electoral role they're most familiar with. They're just going to go with that. So that's one. Second, and I think it's more important, it's political. What would have been the cost of extending franchise at that point? Imagine what's the context of the referendum. And again, if you read Hansard, it's beautifully put by some of the MPs. And one of them says, well, the Prime Minister, David Cameron at the time, was dragged to hold this referendum kicking and screaming. He didn't want this referendum at all. So he was forced. That's the argument that they make. Someone else says it was a gamble, and so on. So if that's the context, what's the political cost for the government of extending franchise? The reasoning was the government always thought they were going to win the referendum. And they thought they could pull through with a Remain vote with the existing franchise. So the idea was, at that point, I think they kind of realized that the results might have been closer than they hoped for. So the idea was, if we extend franchise to European Union citizens who are clearly expected to be pro-EU, or that's the expectations, and 16, 17-year-olds, again, from polls and surveys, being in favor of membership of the UK to the European Union, then the government might be accused of stacking the numbers for the referendum. So the idea is that we need to pull through in the cleanest possible way. And that's in relation to the context of the referendum. And of course, you know, that we know that backfires dramatically. And then we get to my third level, which I think is where more work is needed, and it's the ideological level. And it is, how is the political community imagined in the UK? Do we have a sense of British identity? Is it shifting? How does it change? And what's the role of the law in dealing with that? And I think, you know, when we talk about this notion of the British people that is being used around quite so much, I kind of want to draw a comparison with what Sebastian was saying about parliamentary sovereignty being the principles. Now, we go to conferences, we talk to colleagues, and there is this idea bandied around that it's the UK Constitution is about popular sovereignty. And we're like, no, we're not the US. So there has been a lot of that kind of debate. So with regard to British identity, and there's also this idea of inclusion of Commonwealth citizen. And I was reading a really interesting, very short blog piece from the Institute of Commonwealth Studies. And there's actually, I wasn't aware of that, there has been a petition which was signed by over 40,000 people to exclude Commonwealth citizens from voting in the elections. And of course, there has been a report from the conservative, right-wing think tank, Migration Watch UK, basically arguing that there were between 894,000 and 960,000 Commonwealth votes at play. But, you know, the idea was that that was never really quite, part of the electorate was not courted, and political parties didn't quite know what would happen to that. So those are some of the thoughts that I wanted to offer. And I wanted to conclude with this relationship of the UK stranded between these two multinational organizations, the EU and the Commonwealth. And what I've seen, well, in the debates, looking at Hansard to begin with, looking at the papers, looking at public debate and engagement in the UK in the last couple of years, it seems that there is an idea of growing connectedness to the Commonwealth, which to me is quite peculiar as a lawyer, because from a legal point of view, there is no notion of citizenship which is inbuilt in the Commonwealth from an international law point of view, while there is within the European Union. If you look at British passports, like all other European passports, the notion of citizenship is one which is a European one. So looking at the legal basis of the organizations gives me something to think about. But also, and I think that's part of my other hat as a legal historian working on decolonization and so on. That's actually how the project, the idea of this talk came about, was from an essay by imperial historian Max Beloff, Empire Reconsidered. This was written in 1997 at the 50th anniversary of the independence of India and Pakistan. And you have an eminent Oxford historian who's drawing this comparison. And it's the idea that joining the European Union, especially after the Maastricht Treaty, is that we're sacrificing important Commonwealth interest vis-à-vis Europe. And I think that to me is quite significant to look at how this image is constructed and the idea that it was an either or. When, if you look at declarations from Commonwealth head of states, everyone supported the Remain campaign, including the Commonwealth Secretariat itself. So it's quite interesting to look at this kind of configuration. And I'm wondering in a lot of the press whether politicians and some segments of the media are thinking about the Commonwealth or are really still thinking about empire. And it's with that thought that I leave you. Thank you so much.
Actually, there's two common threads that run through both of those topics. I mean, one of them is about the way in which laws, in effect, kind of a mask for more powerful political forces, and legal rationales are sort of cooked up in a way to explain or rationalize things for which there are great political pressures in favor of or against. So I think if you look at the decision of the UK Supreme Court in Miller, I think that's, if you look at it from a pragmatic or strategic perspective in terms of what the court did there, it was, I think, the safest path. It was the path of least resistance. So on the one hand, they do something to placate an audience that would be very, very worried about Brexit just sort of steamrolling ahead. And on the other hand, they do something to placate an audience who would be, I think, outraged if Scotland, for example, could veto the process. And so they find a place where they're not really making anyone too unhappy. I mean, some people are unhappy, but no one's too unhappy. No one's outraged, really, by the Miller decision, I don't think. I mean, people can comment on the legal reasoning and say there are some problems here, but I don't think it's the kind of case that decision that's going to make rioting in the streets. Whereas I think that had they gone in a different way on it, it might have created some quite serious problems. So political problems, practical problems. So they did something pragmatic to sort of pass the least resistance. And then maybe that explains, we can't find a satisfying legal rationale for every aspect of the decision, precisely because the core engine behind it is something else. And then likewise, I mean, this story of the franchise it's a strange story, really. When I lived in the UK, I was especially actually leading up to the Brexit referendum, I was completely perplexed by the fact that I could vote as a Canadian citizen in this momentous decision. And Italian friends of mine who were residents in the UK for years couldn't vote. I mean, that's amazing, I think. It's like a really bizarre outcome. So yeah, I mean, there's something strange about that. So let me identify another connection between them, which is really about the kind of medieval or archaic quality of so much about the way the United Kingdom still works, despite the fact that here we are in the 21st century. I mean, the lack of a codified written constitution is anomalous, and the lack of a kind of clear understanding of what is the citizenry. You still see the word subject gets kind of bandied about. And it's not clear that there is a kind of concrete notion of citizenship at all there. It's still very much reliant on some quite old-fashioned ideas. It's a very strange thing that this country has been able to survive into this century with all these archaic qualities. And I suppose people at one time would say, well, it all works very well, and that's why it's survived. Maybe it isn't working so well.
Yeah. I would certainly agree with that.
Maybe there's now a new impetus for change. So I would just like to, get your thoughts and reactions on that, if you can.
Should I respond on the Miller point, or in this Mara?
Say more about the devolution question, which you flagged earlier.
Well, I mean, in terms of your interpretation of the outcome as sort of the least dramatic, as it were, I mean, it's quite complicated, the question of how judges reach their decisions and whether it's a mask for political force or not. There's an intangible element in the decision-making process. So it's, that makes it very difficult for us to say for sure. but as observers, you can say the outcome is such that it looks as if it was if not the least disruptive, there were more disruptive options. And I agree entirely, because what if the court had said you can only proceed with Article 50 if you have the permission of the devolved assemblies because of the Sewell Convention and the Scotland Act 2016. That would have really, as they say, put a spanner in the works. That would have created a real problem. So I think in terms of your analysis of outcomes, I certainly would agree. And I do agree on, there's a theoretical aspect of what you're saying, which is judges are acutely aware in these scenarios of political outcomes. Whether it's a mask, I think they have, let's say, dual loyalties. They are trained as lawyers, they believe they should uphold the law, they should reach the best possible outcome. So I think that's a question in good faith. I think they act in good faith, but undoubtedly they're also acutely aware. How could they not be? They've got the press and people demonstrating outside, so you're right. But I do think, and that was really the point of my talk, that it shows whatever one says about the different options. The point of my talk was not it should have been this result rather than that, but that their position shows their fundamental weakness in the existing scenario. Because I think if they'd thought in serious terms about the nature of the UK Constitution as it's developed and given effect to it, there would have been a very different answer. So that's one aspect. So I think there was, I wouldn't say cowardice, I wouldn't suggest that, but they didn't, I suppose the take-home message for me is they're not functioning as a constitutional court, thinking about deep constitutional issues and what the appropriate solution should be. And this sort of sea of unstable ideas that are being batted around in their reasoning, some of which are historically dubious and analytically arguable, seems to me to be a product of the system we have. So I agree. When you say it all works well, that's the sort of platitude people congratulate themselves. The evolution of the British Constitution is a wonderful object. Well, it's not a wonderful object. And it certainly, that was my conclusion. They need to get rid of the arcane elements. It doesn't presuppose what the distribution of powers can be, but at a functional level, I don't think it's good for a country to have a set of legal arrangements and a constitution where nobody's really sure what is there. And, for instance, they quote, an example I didn't give, they quote Dicey, and they give that a little element about the sovereignty of Parliament, which every academic recognises in the UK context, because every student always says it. There are 3 elements to the sovereignty of Parliament and so on. And it's in every sort of quick guide to passing the exam. There it is. And it appears, if you don't mention Dicey, it still appears in the answers. But it's extraordinary they just present this sort of little dollop of Dicey when it's quite clear that Dicey completely changed his mind about parliamentary sovereignty, that he actually argued for the political and legal sovereignty of the people. And there's no reference to that at all. Now, of course, one of the consequences of, if they're going to advance Dicey as authority, would be, you could say actually worked in the government's favour, because if you take Dicey's later mature view seriously, that would imply the referendum should be decisive, and therefore, the prerogative, there's nothing wrong with an executive power, but it's just an example of, they obviously, I don't know if they're happy with the product, but it's a product of a particular system which, in my view, needs a radical change. Whether there is any taste for that's another matter. There's a standard sort of riposte to that. I don't see a constitutional moment. That's what academics like to say if they don't like the idea of a written constitution. Well, there may not be. I think there should be.
Yes, so just on a couple
couple of small points. You described the franchise as bizarre, and I think that links well with your assessment of the law as a mask for more powerful forces. And I think what we see here, and sometimes as lawyers we ask, how does the law work? How is it interpreted? And sometimes we have to ask, how does the law come to be the way that it is? I think in this instance it's quite a simple case of an elective dictatorship, that you have the government bulldozing through a position of franchise. So from an institutional point of view, that's the clear-cut explanation. From the point of view of the political will behind that, I think it was hubris. I think, they just thought they were going to pull through, and that was the formula for franchise that would have had the lowest political cost. So that's my assessment on that. On the medieval and archaic way in which the Constitution functions with regard to citizenship, I would agree with you with regard to the history and the basis. But that's also within the framework of a modern state. So I don't want to go all Foucauldian on you, but looking at the latest blunder of the Home Office sending letters to EU citizens who did not qualify for permanent residence, saying that they were about to be deported when that's not the case because they still have legal entitlements on the basis of EU law. That seems to me that it's just a combination of the worst of the modern with the worst of the archaic.
That's a damning criticism.
Well, we have time for one or two questions, but I'll have to be quite strict because we need to leave the room short to make way for other things going on. So if anyone wants to ask, yes, please, thanks.
Thank you very much. Well, thank you. This was absolutely fantastic, extremely interesting. I've learned a lot. I'm not a constitutional myself, but I'm one of those living in the United Kingdom not able to vote. So what I was wondering is, in a comparative perspective, is what we have experienced or what you have singled out in the United Kingdom in the way this franchise is constructed, if we can compare it somehow with what is going on, what has been debated extensively also in the United States with the so-called gerrymandering idea, the idea that actually we can, politicians can manipulate the constituency to, so that they can favor one class or another, and therefore in hope of influencing the outcome of a given election. And that's something highly debated in the United States and, making to the news and so on and so forth. But so I'm wondering if, in a very crude way, this actually can be a phenomenon that is also encountered in other jurisdictions, and then therefore also regardless of the constitutional shape or the formal constitutional, let's say, design of a given country. I don't know if it makes sense. I mean, you are the expert, and I would be very happy to learn. Thank you very much.
Yeah, please respond as you like.
Well, I think it was aimed at you.
All right. Thanks, Giuliano. That was a great question. I think there are two different levels, and I think in the UK we had a massive debate about the electoral system. There's been the AV referendum that was put forward by the Lib Dem that failed miserably in 2011, but it hasn't. And I think the good point was that that's a good parallel because we had a referendum on the electoral system. The electoral system was not reformed. The UK retained for Parliament a majoritarian electoral system, which comparably to all no one of the other devolved assemblies has a majoritarian system. They all have different kind of AV and mixed systems. But at the same time, the referendum has not extinguished the debate, which remains, which is the question of what do you do? Although, we've seen the last 2 out of the last 3 elections we had hung parliaments. So I think, that's still up for grab. With regard to the referendum, I think it's slightly different because it's not divided by constituency. It was just a sum of votes. But I think the question is more, I think it's comparable from the point of view who votes rather than who votes where in that sense.
Thank you.
Yes, please. Thanks. Sorry, if you could introduce yourself.
Well, thanks very much. Two very interesting talks. I'm Rehan Abiratna. I'm a relatively new member of the law faculty over at CUHK on the other side of town. A question for both speakers. For Mr. Payne, I fully agree that the UK could benefit from a written constitution, but assuming that there isn't a political moment or a constitutional moment, I wonder the degree to which you think if Brexit happens, and let's assume if Brexit actually happens, and the UK Supreme Court no longer has Strasbourg looking over its shoulder, might it develop into more of a constitutional court on its own? That is to say, there might be a kind of political space that opens up in the UK where there's a kind of yearning for a more powerful court, maybe a more rights protective court, and that might kind of develop organically as British constitutionalism is supposed to do, even in the absence of a written constitution. Just a thought. And for Dr. Malagodi, this is a very basic question, so I mean, apologies if it's ignorant, but I mean, the idea that some residents who are not citizens can vote and others cannot just seems prima facie arbitrary to me as a lawyer. Like, is this a subject of litigation? I mean, it seems like it would even fail like a Wednesbury test, much less like, at the European Court. So I mean, history surely is not a legal reason. Like, obviously that's the reason, but that's not, I understand the Scottish version, which makes sense. All residents have an interest in the future of Scotland, so they should vote. I understand, though I don't fully agree with the idea that only citizens should vote, but this in-between one just seems completely arbitrary as a legal matter.
Right. Shall I go first? Yes, please take the floor. Well, you mentioned the Strasbourg Court, and that, of course, begs the point whether, as instalment 2, a Conservative government repeals the Human Rights Act. So I don't know what might happen, although you're obviously asking about, suggesting the possibility of a Supreme Court developing more as a constitutional court. Well, I think it connects to Alex's point earlier about the interconnection between law and politics. I rather think it depends on the political scenario after Brexit. So, if, for instance, the UK leaves the European Union and then the economic consequences are disastrous, and if governments become more right-wing and carry on blaming people over there for everything they can think of, including human rights, and the rise of British nationalism. I mean, that seems to me to be a rather an environment not conducive to the Supreme Court feeling even more confident or even less. I mean, I don't see that as a scenario conducive to a court feeling bolder than they did in the Miller case.
Thanks, Ryan. Great question. Actually, Alex Salmon raised that point in Hansard. So he actually said, I've got the quote right here, is urging the government to consider exactly the point of discrimination and how they would defend that in court. I think on the issue of litigation it was considered, but I think it didn't go through. I think it was raised, I read it in a number of places. The issue is that, in my view, I think the idea was that the Remain campaign thought that it could win without European Union votes, and if they had won by a tight majority after litigation and securing the EU votes, the vote at the outcome of the referendum would have appeared to be less legitimate because of that. So I think everyone was quite certain, including the bookies, that the Remain campaign would win. So I think, it's taken a nation by shock, I think the morning after. So I think litigation was not, and then I would assume it was just too late. It's just the referendum has taken place.
I saw a hand go up over on this side of the room. Yeah, so we can take one more question. I think we have time for. Thanks.
Thank you. My name is Liam. I'm a year 2 law student here. I want to ask I have a comment/question for Mr. Payne. I think that there are two main issues with the written constitution, and that is, firstly, the interpretation of constitutions can create a lot of issues. For example, in the US, it's a main reason for racism, racial segregation, and many other human rights problems, especially after 9/11. And in Hong Kong, it has created a kind of nebulous definition of what the role of Hong Kong's government should do. So the problem with it is that if you give the Supreme Court the final say of interpretation, which is what common lawyers would do, that people can't vote out the justices from the Supreme Court, and that there is no political pressure to keep parliamentary sovereignty and certain human rights principles in place, and they can adjudicate cases in any way they want without being checked, essentially. And the second issue is the practicality of adopting a written constitution in the UK at the moment, because, for example, the Parliament is currently stuck with many legislations and has to pass many laws, and I just wonder if the benefit of clarifying these constitutional settings is worth sacrificing vast amounts of time to legislate on other issues. And I just think that the current unwritten constitution better ensures the parliamentary supremacy and democracy, because the Parliament has the final say, even if the Supreme Court says otherwise. Yeah.
Well, if I may say so, I think that's a superb set of comments. I thought it was really interesting, and I completely accept the point you're making. I hope it would be obvious that I've reflected on this. I understand that written constitutions don't solve all the problems, and of course, as you rightly say, the Supreme Court is put in a different institutional position. Then you refer to the US, and of course, well, the US Constitution allowed humans to be regarded as chattels, and that seemed to be fine under the US. So, I mean, I accept it's not the perfect solution to everything. You also refer to Hong Kong, so what your comments indicate is, to me, one of the things, I mean, apart from the perfectly fair and right point that a constitution doesn't solve everything, the outcome is also going to be context, country-specific. And my view is that given the nature of the UK and its general political climate, a written constitution could work very well. In other words, I think there are many very admirable qualities about the political and legal system. And I think a written constitution, I think the judges would still be sensitive to political issues in the way that, I mean, your sort of picture is there of the judges who then become the menace because they can do whatever they like. And then the next question is who appoints the judges. So I understand that, and I think there's plenty to be discussed. I think that's why it's a brilliant set of comments on your part. I think in the UK, given that it is really quite a stable and, broadly speaking, fair society, I think a written constitution could be worked very well. As to whether I think it's going to happen anytime soon, I don't think it is. Do I think it should happen? Yes.
Well, on that note of potential reform, I'll call proceedings to a close. I want to thank both of you for a really thought-provoking, inspiring set of presentations. And I hope those here will join me in thanking you for your...
Thank you. Thank you for the invitation.
No,